Good morning. Are you Johnny Jacobo Ramon?
Yes.
And Mr. Ramon, you were previously in court and entered a plea of guilty to the second-degree felony offense of accident involving death. And that was a plea agreement of a cap of 15 years in prison. I have received the pre-sentence report. Has everyone had an opportunity to review that report?
Defense has.
Yes, Judge.
Are there any additions or corrections?
No, Your Honor.
Not from the state.
Mr. Burbank, you may proceed.
Your Honor, this is a tragic accident. If you read the factual basis, which I know you did, person was walking across the street at nighttime, and cars swerved, and my client actually hit him. As reflected by the charge, he failed to stop. He panicked, as in reference to his version, that is on page 1, and then was stopped up in Lumberton. He's been employed. He has family up in Woodville. He's been employed. He's got one problem. He is not a U.S. citizen. I would be arguing for probation in this case, but it is my understanding that there is a hold on him by immigration, and that he probably will not, if he got probation, he wouldn't be released. He has 2 prior DWIs from Tyler County that were taken care of. At the same time, what you receive, basically time served, 90 days jail. The intoxication charge that I believe is from Hardin County was when he was arrested, and that's been dismissed or rejected by the, and probably because we're down here, they probably did it. Your Honor, I asked for there's a death involved, and I would love to have the minimum in reference to penitentiary time, but I'm asking for mid. I think that 15 is probably too harsh, and that's my opinion, especially in light of the facts and circumstances of this, in which the person was walking across the street at the time and being blocked by other vehicles, and other vehicles had to get out of the way. But he was definitely wrong in not stopping, and he was intoxicated. I would ask for anything less than the 15, because I know where he's gonna go, and that's a sad thing, but he's not here legally. And I don't know if he would like to address the court.
Sí,
Yes, sí.
Go ahead.
quiero decir que lo siento, que si lo hubiese visto, yo me hubiese detenido antes para poder auxiliarlo, pero pues
Hold on.
Judge, I'm so sorry. Had I seen him, I would have stopped and helped and rendered aid.
pero pues había un carro con
Hold on. Hold on. So are you telling me that you didn't know you hit someone?
¿Me está diciendo que usted no sabe que le pegó a alguien?
No, sí.
I did know.
Okay.
Y pero pues había un carro enfrente y yo no lo pude ver
There was a
antes.
vehicle in front and I wasn't able to see him on time.
Okay.
Pero pues quiero decir que lo siento, que
I want to say that I'm sorry.
si pudiera volver el tiempo lo haría, pero
But
sé
if I
que
could go back in time, I would go back and
soy
help.
el culpable.
And I know I'm guilty.
Okay. Thank you.
I just have one question of him. What were you doing for work?
¿Qué estaba haciendo de trabajo?
Estaba en el roofing.
I was a roofer.
And how long have you been in the country?
¿Cuánto tiempo ha estado aquí en los Estados Unidos?
14, 15 años.
14, 15 years.
And have you always had a job?
¿Siempre han tenido un empleo?
Sí.
Yes.
And you do have a family?
¿Y si tienen una familia?
Sí.
Yes.
Thank you. Mr. Smith?
Judge, we would argue for the max sentence in this case under the plea agreement based on the fact that when he struck him, he knew that he struck him. That was evidenced by the phone calls the next day. He knew he hit a person. When he was stopped in Koontz, which is a long way from the accident scene, he told the police when they noticed the damage on his vehicle that he had struck a deer. They, either through dealing with him before or suspecting that he was lying and knew he was intoxicated, went all the way back to the county line looking for a deer that had just been struck. And only because they were diligent in doing so did we even know that he had committed this particular crime. He knew he committed the crime. He lied about it. He has an issue with alcohol. He's here in the country illegally. I would direct your attention to the jail report in this case and how he's acting, showing disrespect for staff as well as masturbating in open bunk. We ask for a 15-year sentence in this case.
Mr. Jacobo Ramon, obviously the facts of the case are terrible. The fact that you didn't stop, the fact that you were intoxicated, and in addition, and I'm not even sure that when you were in our jail for some amount of time, there was a requirement that I release you because of the amount of time that had gone from the time of the offense while you were sitting in custody. I did that, and then you didn't show up. You are here illegally and have now killed someone. I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. And at this time, find you guilty of accident involving death. Sentence you to 15 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. It is in Spanish. I advise you to read that. If you are ever back in Texas legally, you will not be able to possess a firearm or ammunition. That could lead to more charges against you. All right. Thank you. You can go back with the bailiff. Thank you, Mr. Burbank. Thank you, Ms. Burge. Of robbery, a second-degree felony. We were previously here, and she entered pleas of true to counts 1 through 12, all of the counts in that motion, second amended motion to revoke unadjudicated probation. I received the updated pre-sentence report as well as a letter from Ms. Dugas. Has everyone had an opportunity to review that?
Yes, Your Honor. Yes, Your Honor.
Are there any additions or corrections?
None from the defense, Your Honor. Not from the state.
All right, and this was unagreed, correct?
It was a cap. Cap of 8.
Ms. Holmes, you may proceed.
Thank you, Your Honor. I've spoken with Ms. Dugas. Obviously, the various new offenses and violations is not acceptable through probation. She understands that. She stated that throughout this time, she did not have much support. She was going through a hard time in life, and she resorted to doing and committing these offenses not being in obviously the right state of mind to be able to successfully complete probation. Ultimately, Ms. Dugas is requesting to have the opportunity to be reinstated to complete probation, and she would like to address the court in regards to this as to her plan of how she can successfully complete if given the opportunity.
Okay, go ahead.
How you doing, Ms. West? I'm wasting your time. When I get out in the world,
Speak up.
when I get out in the world, I'm going to do everything in my little power to complete this probation. I know it's going to be extended if you do grant it to me. By getting me a job, staying out the way of bad company, being a better mother, being there with my family more often.
Ms. Dugas, you did the exact same thing. You robbed someone else while you're on probation for robbery. Not just robbed someone else, you failed to ID, failed to report to probation, you committed the new offense of possession of a controlled substance, you resisted arrest, it's ridiculous to me that you're saying you want a second chance, because this was your second chance. You've already been on probation. You were given the second chance of not going to prison. The fact that Ms. Holmes negotiated a cap of 8 years for you, you should thank your lucky stars. This is ridiculous. 8 years, in my opinion, is not enough. You had every opportunity to do all the things that you're taught. Stop crying, because you weren't crying when you were robbing people and using drugs and not being a good mom and not doing the things that you should have done when you were given this opportunity, right?
Yes, ma'am.
Ms. Malvino? Sorry.
I don't think I need to add anything to the board. I think if you follow the agreement that 8 at the very least is appropriate for her based on the number of violations. I spoke with Mr. Chang yesterday. He does not want to continue to work with her. This is actually her third NTRB, so without her 5th chance in front of you, not just her second chance, and I think that she's purpose.
Ms. Dugas, I'm going to find that you entered your pleas of true to counts 1 through 12 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time, find you guilty of robbery. Going to sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes. I hope you take some advantage of this and actually do what you're saying you're going to do when you get out and change your life. There's programs in prison, take advantage of them, but you're not going to continue to get opportunities like this. If you continue to violate the law after this, you're going to be considered a habitual offender. And if you do anything again, your minimum punishment is going to be 25 years. 25 years minimum for what you've been doing. So you need to change your life, or you're never going to see your kids, right? Go back with the bailiff.
Judge, would the court be willing to entertain an 8 concurrent so that we would have that
Yes,
individual
yes,
down
ma'am.
the road?
Yep, if y'all want to get that taken care of, that's fine. Brianna Williams, Mr. Parker. All right, ma'am, you're Onisha Dugas?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Sheila Aaron.
Ms. Dugas, in cause number 24, DCCR 1603, you're charged with the second-degree felony offense of robbery from May 26th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with? I have some documents here on the computer that have your signature on them that the state has marked as Exhibit Number 1. Before you sign these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Anna, I just touched something and it went away, and it's saying it's, I don't know where it went. Is that it? Okay. Thank you. I just needed you to get up. I could figure it out. Okay. And there's no evidence that Ms. Dugas is not competent.
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of robbery. Sentence you in accordance with that agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on this sentence for any time that you've been in custody that the law gives you the right to receive. This will run concurrently with the other case, which means at the same time. I'm handing you the trial court certification that shows this was an agreement that I followed, and therefore you have waived your right to appeal. All right, good luck to you, ma'am. You can go back with the bailiff.
This courtroom session shows how quickly a second chance can turn into serious consequences. In one case, the judge imposed a 15-year sentence after considering the defendant's guilty plea, the circumstances of the incident, and the arguments from both sides. In another, probation was revoked after multiple new violations, leading to an 8-year sentence. Other hearings focused on strict bond conditions, restitution, and plea decisions. The overall message is clear. The court may offer opportunities, but ignoring the conditions can change everything.
Good morning, sir. Good. You're Tajuan Mack?
Yes, ma'am.
And Mr. Mack is charged with criminally negligent homicide. And Mr. Rojas, what is the announcement?
Judge, my understanding is that Mr. Mack was on bond and he was set today for a patch review, drug patch.
Oh, okay. Okay. Do you have your drug patch? When did you get it?
Tuesday.
So when was the last time you had it before then?
I would say, like right before the holidays.
Why is that?
I honestly didn't know how long I was supposed to have it. Like, it never came like with a.
When you get it, they tell you. When you get that drug patch, they give you all the instructions. I'm sure of that. And they say you have to go back.
They never told me how long I was supposed to have it.
You're supposed to have it until I tell you not to have it. It's a condition of your bond.
Okay.
You don't get to just choose when to not have it. You're supposed to go get it done every 2 weeks so that I know you're clean. Have a seat in the jury box. Let's get you tested this morning.
Thank you, Your Honor.
Okay, and he says he hasn't qualified. You tested negative, which is good, obviously. So it's important that you understand. Condition of your bond is that you have that drug patch on until I tell you otherwise. Every 2 weeks, you got to get it changed.
I just didn't.
If it comes up positive, obviously there's going to be a warrant and you're going to be back in jail. So stay clean, keep it on there so we don't have any issues, okay? So, Mr. Mack, since you've made bond, you were initially in custody for some time, correct? What I'm going to do, or what I require you to do, is try to hire a lawyer now that you've bonded out. And so, are you working? No? Why aren't you working?
I have a job coming up the beginning of next month.
You do? Where's that?
Kansas.
Oh, you told me about that already.
He was here Monday, actually, on the initial docket, and then we found out that he did not have it.
That's why I had you come back today. Okay, so you've already got, when was that next court date gonna be? We're gonna, so same rules applies last week, when I told you to hire a lawyer and all that. Okay, so we're gonna give you a new reset with maybe a different date on it today, for you to have some time to try to get someone hired before the next court date. Again, if you don't, talk to at least 3, bring me all that information when we come back, follow all those rules of bond, and then we'll see you at your regular court date, okay? Step in front of the clerk, she'll give you that reset notice. Gonna get some help?
Oh, well, I have BMW on the way, but I have run flat tires.
Oh, good,
So
but still.
it's a nightmare.
I'm sorry. Good morning, sir. You're Bobby Brown? And Mr. Brown was previously in court and entered pleas of guilty in both cases, state jail felony, forgery of financial instruments. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Yes, Your Honor.
Are there any additions or corrections?
No, Your Honor.
Not from the state judge.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. In cause number 23, DCCR 1496, find sufficient evidence to find you guilty, and at this time find you guilty of forgery of a financial instrument. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but probate that. You'll be on probation for 3 years. You're ordered to pay, there's not a fine, but you are ordered in that case to pay restitution in the amount of $744. Follow all of the rules and conditions of probation. In cause number 23, DCCR 1497, also find sufficient evidence to find you guilty, and at this time find you guilty of forgery of a financial instrument. Sentence you in accordance with that agreement to a term of 2 years in the state jail prison, but probate that. You'll be on probation for 3 years. You're ordered to pay restitution in that case, the amount of $1,280.80. Also follow all of the rules and conditions of probation. If you do all of that in both of these cases, then for all practical purposes, your cases here in court are over, and you'll be able to serve that 2-year sentence while you're out on probation. The other side of that, however, is if you violate any condition of your probations, then you can be brought back into court, and then you could be serving your probation revoked and serve those 2-year sentences that you've agreed to. Do you understand? And I know 3 years seems like a lot of time to pay back restitution. A lot of people will think, I'm going to wait till my tax refund comes back, or I'm going to sell this. Start making payments immediately. It's very important to me and obviously to the victims that they get paid back. Even if it's a little bit every month, it'll add up. So, I mean, if you have $20, that's better than $0. If you have 100, it's better. You know what I'm saying? Don't wait, because what can happen is at the end of your probation, you could have done everything else properly, followed all of the rules and conditions, and come in and on motion to revoke your probation because you didn't pay. And if I find that you had the ability to pay and you didn't, you could do all that right and still go back to prison for 2 years. You understand? All right, I'm handing you in each of the cases the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm, that's for him, a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with your attorney. All right? If you'll just have a seat here in the courtroom, probation's going to call you up when she's ready to go over your paperwork. Good luck to you, sir. Thank you, Ms. Simpson. Good morning, sir. You're Jerry LeBlanc?
Yes, ma'am.
And Mr. LeBlanc, in cause number 21-38605, you're charged with the state jail felony offense of theft, and that's from August 27th of 2021. What that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 6 months and up to 2 years in a state jail prison. Do you understand? And then in cause number 22-40408, you're charged with the state jail felony offense, stand up straight, the state jail felony offense of abandoning a child. I got a bad knee too. Stand up. You're charged with abandoning a child, and that's from August 27th of 2021. Same thing if you're found guilty. The range of punishments between 2 years and 6 months and up to 2 years. Do you understand? And it looks like I have a plea bargain rejection. Is there just one?
There should be one for each case, Your Honor.
And are they the same?
They are.
So it looks like the state has offered, if you wanted to enter a plea of guilty in your cases, an 18-month term in the state jail, prison, or a cap of 20 months. If you did that cap of 20 months, it just means that you would leave your punishment up to me. I couldn't give you more than 20 months. I could give you less. It would depend on the information that was brought to me at a sentencing hearing. You have every right to reject that and have both of your cases set for trial. I just want to make sure you understand what your possible consequences are if you go to trial and what your options are. Question?
You will be my judge. Will it be different?
No, I'll be your judge whether it's a trial. So if you...
Thanks, because he told me it's a possibility it could be the first one.
There is a possibility. There are times when there's a trial set, and let's say I have a very serious case, or I have a lot of cases on that docket, and there's another judge who has a jury and their case settled, and they send a message over that says, hey, do you have any cases? And so your case could get sent out to any of the other judges for the most part. It could be one of probably 3 or 4 that are willing to take these cases. So that's up to, that's a possibility. I don't know that there's any real legal objection that you could have to that. There might be. You could talk to your attorney at the time. I don't typically send out cases, but I can't promise you that I wouldn't, if that makes sense. Just so knowing all of that, do you want to reject those offers and have your cases set for trial?
Yes, ma'am.
Okay, so we'll get your cases set for trial. Mr. LeBlanc, Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me here as a court-appointed attorney. With your permission, I can release him and appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you?
Yeah, he told me that.
Sure, okay. So what we'll do, Mr. Rojas, you're released. Mr. LeBlanc, if you'll just have a seat over here in the courtroom, the clerk will call you up when she's ready to give you all that information.
Your Honor, this is a reduction to a Class A theft.
Okay,
It's a shoplifting. I got a little out of control, but
thank you. Let me get that pulled up. Let's see, are you Anthony Patterson?
I'm gonna try to see. So I need to be ready for this day.
Yes.
Sorry, give me just a second. And will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Patterson, in cause number 24, DCCR 144-1774, the state has elected to proceed on the lesser included offense of a Class A misdemeanor theft from August 15th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed them, did you go over them with Mr. Rojas? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 2-year deferred adjudicated probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Is there any restitution, or it was
No, Your Honor.
recovered? All right. And are you a U.S. citizen? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Patterson is not competent?
No, Your Honor.
You all right? Very fidgety.
No.
Have you been in trouble before?
she had one refused case as an adult and at least one juvenile case in Harris County.
How old are you? If I test you this morning, you gonna have anything in your system?
Yes, ma'am.
Okay, let's see what all's in it. Have a seat in the jury box.